Good evening to the participant of the SLW670. Karibu sana. Welcome to my today class. Yes, if you happen to see what is I posted on the screen, it's the patent law, and which I highlighted in the red color the jurisprudence developed by the courts. And today that we will see how the jurisprudence developed by the courts in Tanzania. This aspect that we'll concentrate on today class. So here I have made the 2 points here. Patents in Tanzania, what, why, and how. So there are two parallel legal systems governing the intellectual property in Tanzania regarding the patents are concerned. So in Tanzania mainland, the governing patent law is the Patents within parenthesis Registration Act, that is a Cap 217 revised edition 2002. In addition, pursuant to the WTO TRIPS agreement, and this is the international agreements, instruments, the conventions on the biodiversity, CBD, and the International Union for Protection of the New Varieties of the Plants, that is the UPOV, and the Tanzania mainland. It is the Tanzania mainland enacted the Protection of the New Plant Varieties, Plant Breeders' Right Act 2002 to provide a framework for the protection of right to new plant varieties. So new plant varieties, the patents are concerned, and how the Tanzanian courts will deal such issues if any conflicts or dispute comes in the patents. So the United Kingdom Design Production Ordinance Cap 219 of the 1936 and an archaic piece of legislation that is still in force when our law will be silent at the time that we will take the adapted laws from the other countries. In Zanzibar, patents are regulated under the Zanzibar Industrial Property Act 2008, which repealed the Patents Decree Cap 157 of the 1932. So how the patents will deal in the Tanzania mainland and how patents issues are covered in the Zanzibar. Because Zanzibar, the present legislation is Zanzibar Industrial Property Act 2008 is there because it repealed the Patents Decree Cap 157 of the 1932, the old one. So inventors can also obtain the patents through the African Intellectual Property Organization, that is ARIPO. It is one of the regional organizations where protection of the patents. The African Regional Intellectual Property Organization, OAPI, also is one of the organizations which will make the protection of the patents in Tanzania. And other patent corporation treaty, that is PCT, in respect of which Tanzania is a member. So in those organizations, regional organizations, as well the treaties, Tanzania is a member for that one. Such patents have the effect in Tanzania mainland and Zanzibar, just like a patents granted under local legislation. How the local legislation granted in the patents in the same way, the earlier two parallel, one is in mainland of Tanzania, another is in Zanzibar. How the jurisprudence of the patents will go and the cases will be decided in Tanzania. So an inventor is granted an exclusive right to prevent the other forms commercially exploiting his inventions for a limited period of time in exchange of the detailed public disclosure of the inventions. So any inventions would be there is a particular limited period of time would be there, then we can have the right, either it is a patent right or a copyright or any other intellectual brain work is there. So this way, Tanzania should consider the patenting their inventions, how the Tanzania mainland as well as in the Zanzibar, the patent invention would be protected and the jurisprudence will be there for the patents. So a patent also provides a return on an investment in respect of the time and money invested developing a product or a process. So for each patent, there would be a certain investment also, how it can be made and develop the product and process, which would be the easy for the people to buy it. When a marketable range should have to be kept it over there. That's what I want to say. So, moreover, if Tanzania SMEs, which make up the majority of the business operating around the country, have a portfolio of patents, they are likely to draw more interest from potential investors, leaders, and to enhance their market value. So, what is covered over is Tanzania mainland having its own caps and the Zanzibar having the own act, but is based on the international instrument where the Tanzania is one of the member to the party for those international instruments. The term patent protection in Tanzania maintained is 10 years by virtue of the Section 38, subsection 1 of the Patent Registration Act, Cap 2017, in the mainland of Tanzania. Yet, under ARIPO, the term of the patent in each member country is 20 years. That is the time period would be given. So, the time period for the given in the Tanzania mainland is 10 years by virtue of the 38 one of the Patent Registration Act, but the regional instruments are concerned where the Tanzania is one of the party and they made the patent in each member country is 20 years. So these are the two aspects of his. ARIPO is 20 years and the CAP 217 is the 10 years. In Zanzibar, the term is 20 years in according with the section 13.1, the subsection 1 class A of the Zanzibar Industrial Property Act 2008, which is the new act, and the earlier decree is repealed. In both the sides of the union, patent rights begin with the patent is issued and the term of the patent can be extended subject to the statutory time limitation. Timothy, are you there? Say yes. Timothy, are you hearing me? Unmute and say yes. Timothy, are you hearing me? I could see that you joined it. Unmute and say yes. So that
Yes.
Yes, well and good. So two parallel how the Tanzania mainland will work and how the Zanzibar will work regarding the patents jurisprudence is concerned to decide the cases. So for an invention to be patentable, it must be new, involve an inventive step, and be industrially applicable in solving the specific problem in the field of technology, and it may be related to the product or process. Whatever the product or the process would be there regarding the patents which are invented, it will be the new one and unique one. With that, it can be registered in the mainland and it can be also registered in the Zanzibar. So the first step to getting a patent to engage an experienced lawyer to search relevant patent databases. So if a person wants to do the cases in the patent, in the disputes are concerned, the person who is handling it should have to have a depth of the knowledge in the patent, in the international arena, as well as in the regional area, including the national acts and enactments, including the international instruments where the Tanzania is one of the party. If the invention is unique enough to be patented, the lawyer submits an application to the registrar of the patent at the business registration and licensing agency, that is the BRELA, and which is organization and which will take care of the patents. In the earlier classes also I discussed about the BRELA, the business registration and licensing agency in the case of Tanzania mainland. The application goes through a number of steps, including the preliminary and formal examination. So there are steps would be there. The BRELA will provide if any new invention is made and you want to be protected in the Tanzania mainland, and the BRELA will take care of it, and there is a procedure would be there, would be followed by a lawyer who wants to make it out or the person who wants to make it out. Generally they will approach to the lawyer because lawyer know the many hitches and glitches also. So that is the reason. So if it is refused, The applicant may apply for either reconsideration before the patent register in case if it is refused over there. So the applicant, who is a person who invented it or on behalf of the person invented it, and a lawyer could apply for either reconsideration before the patent registrar or appeal at the High Court against the decision of the patent registrar. Suppose the patent registrar will make a particular point which is not favorable to the inventor or the person who is filing the case, then he can approach the High Court on the decision of the patent registrar in the Tanzania mainland. As earlier stated, application for the grant of the patents may also be filed directly with the ARIPO. There are two ways are there. Directly you can make the ARIPO, one of the regional agency, and where the Tanzania is one of the member, or you can directly register the register of the mainland of Tanzania. So patent application are subject to payment of the prescribed fee. See, without the fees, nobody could do it. The consideration should be there. If there is no consideration, then naturally there is no contract also. Am I right? Timothy,
Yes, yes.
no consideration, no contract. No payment of the fee and no question of registration. So, for registration, you have to pay the prescribed fee, which is fixed by the government. I mean, organization like umbrella. So, a patent owner may grant a license to a third party in terms of the royalty payments. So, a patent owner may grant a license, okay, to a third party and who wants to use it in return of the royalty payment. Of course, the royalty payment would be given at the time the third party can use it. And so licensing patent has the potential to generate the greater profits and encourage the invention. So why you want to make it a patent? That means no one can enrich himself at the cost of the person who invented it. And hence his invention, he wants to register it either in the registrar office in Tanzania or the ARIPO regional agencies are there where the Tanzania is one of the member, he can make the registration. If this registration is there, then nobody could exploit it. If you want, the third party want to use it, he has to pay the royalty and take the license from the inventor. So the courts of law handles cases of infringement of the patent rights. If any person has infringed the patent right, either whoever may be, a third party or a corporation or a person, at that time one can bring an action against the person who such a way infringed the patent of a person. So the Tanzania patent legal regime is intended to encourage the invention that are useful to the society. Suppose if there is no such a production would be there, then people try to exploit on somebody's intellectual brain or invention. Hence, they register it and so that nobody could exploit it. And if a third person would like to utilize it, let he pay the license to the owner or inventor. The inventor gives the license and keeps the restriction also to exploit his invention. So, however, the use of the patent system by especially SME is very low when compared to the use of the trademark system. So, trademark is more in use and patent are less in use. And the subject matter of our next week's article, of course, he have written another article also regarding the subject matter, how the patent would be cases would be dealt. So, under the auspices of the Ministry of Education and Science and Technology, the government of Tanzania is called to encourage the Tanzanians to enter the science and technology, engineering, and mathematics STEM fields to make the heavy inventions in the different fields. So they try to encourage it because they encourage it. The reason is they would like to protect their intellectual inventions unless until they pay the prescribed fee. Yes, Timothy, are
Yes.
you there? You read this. You read this passage which I highlighted.
Yes, settlement lead. However, the use of the
which I highlighted.
Okay. Though through education and
Outreach programs.
outreach programs, many Tanzanians
Tanzanians
businessmen, businesswomen
could be
could
educated
be educated about the benefits of having patents. Yes, could be educated about the benefit of having patent education. Some of which are highlighted in this article.
Yes.
And should we also change the notion that in the notion that in inventing is for
Westerners.
Is for
Westerner people, Westerners.
Westerners.
Okay, enough. See, the point of here is education and other external outreach programs. Many Tanzanian businessmen and businesswomen, they could be educated about the benefit of having the patents. Why the patent should be protected? Why patent should be protected? Tell me.
Because it's an inventions.
Yes, the invention of a particular man brain will be protected because he did the work and other people would like to enjoy on it. If other people would like to use that patent or the product or the process, they have to take the license or they have to pay the royalty. To whom?
Yes.
Inventor.
To the inventor.
Or some of which are highlighted in this article. Suppose I wrote in a book. For instance, my book is there, which is published by the Law Africa Publications, Tanzania, General Principle of Law of Contract in Tanzania. If anybody wants to use any one of the material from that book, he has to obtain the permission from the author and also he has to obtain the permission from the from the
creator.
See, creator is a author. He has to obtain the permission from the author as well as he should also obtain the permission from publisher.
Okay.
And where there is a contract between the author and the publisher. So either author can file a case or the publisher jointly or severally to the person who has violated the copyright. In the same manner, if the patent is protected under the respective agencies or the society or the registered or the Braille law, if any person wants to use it, he has to pay the royalty to the owner and use it. So that is the point. And should not we also change the notion that inventing is for the Westerners? No, inventions only Westerners could do. Not at all. Inventions can be done by any person who is inventing it. But who is inventing it and other people should not try to exploit it, his invention. That's why inventions are protected. Either it is a medicine or it is a crop or it is a fruit or any new thing. It will be protected. So Paul Kibuka, he is the person and he is a tax corporate lawyer and a tax policy analyst, and he wrote this article in the Citizen, that is Isidora and Company. It is the content that counts. So I am also indebted to him. I used his piece of information to impart to my student, not for the sale, for the sake of the knowledge. Am I right?
Yes.
So, and there is another article also there written by, but that is also very impressive article regarding the patents are concerned. So, this is one which I would like to highlight it. Then another thing also there, yes, it is put it here. Patent cancellation and infringement in Tanzania mainland. How a patent can be cancelled and how the infringement could be done if it is done, and what would be the jurisprudence to deal such cases in Tanzania. So patent cancellation is concerned. The cancellation of patent can be done under the two circumstances, and these circumstances include: number one, surrender of the patent. The owner of the patent may surrender the patent to the registrar of the patent. The registrar at the business registration and licensing agency, that is the BRELA, in which the surrender may be limited to one or more claims. The surrender patent shall be accepted if it is supported with a declaration by which the licensee consent to the surrender, and the licensee has expressly waived this, then the right in the license contract. When the said surrender is received by the registrar, he shall remove the patent from the register of the patent, and this leads to the cancellation of the patent. So how a patent can be cancelled over there? Then the file should be moved from the inventor, the owner of the patent. The owner of the patent surrender the patent to the register of the patent to protection, number one, and which surrender may be limited to one or more claims. So claims are there because when he made by paying the prescription, the BELA, and the BRELA also take care of it. The surrender patent shall be accepted if it is supported with the declaration by which the licensee consent to the surrender, unless. So if a licensee wants to surrender it, he can surrender it. And if he wants to prolong it, he can prolong it. But he cannot prolong more than 20 years. Is it clear?
Yes.
So when the said surrender is received by the registrar of BRELA, he shall remove the patent from the register of the patents, because the licensee, the inventor only wants to make it out, and at that time the register of the patent, and this leads to the cancellation of the patent, and that a cancellation of the patent could be done. By whom? By the inventor, or by the person who invented it, or by the license. If a person has taken the license, but the period is there, if the period is over, then automatically he will lose such a license. See, in national parks, a license will be given to kill certain animals, and that license is time bound, and there is a restriction also. You are not supposed to kill those animals which are prohibited to hunt. Am I right?
Yes.
So you cannot kill the giraffe, you cannot kill the elephant, you cannot kill the lion or lioness. What you can kill, like the antelopes or water bucks. I don't think the people will eat the beast also. Whether the people eat the beast meat. Yes. What about the buffalo? Forest buffalo.
What?
Forest buffalo.
I don't know, sir.
So certain things are given the chance to, like stags, antelopes, and I believe water bucks also will be allowed to kill it. So those are the things would be allowed, but the other things are not, could be not be allowed. Ingiri, najua ingiri,
What?
ingiri, Kiswahili.
In
A pig having the
I
two
don't know.
horns in the front, in the mouth. It's like a ingurue, but having the two horns in the near the mouth.
Okay.
What is that?
Uh, ngiri.
In Kiswahili.
Kiswahili ngiri.
Yes.
Nguruwe pori.
I don't know what you say in Kingreza. I think it is it's the forest pig. Boar. So those are the things will be given the license, and the license can be here. A patent can be surrendered by the inventor. Number one. Another thing, the invalidation of the patent. Here the one is surrender. Another is the invalidation of the patent. An application for the invalidation of the patent can be done by any interested person by instituting the proceeding against the owner or the patent, or in the proceeding instituted against any interested person by the owner of the patent, request the High Court of the United Republic of Tanzania to invalidate the patent. Upon the application made by the court to invalidate the patent, the court shall invalidate the patent on the following grounds. How a patent can be invalidated? See, either the inventor, generally the inventor will not go to the court to invalidate it, but other person who says the patent is not in the proper way or proper way it is validated, hence it can be invalidated by on the following grounds. Now let us see what are the grounds should be there where the patent can be invalidated by the High Court. Number one, that the claimed invention is not patentable as stipulated under law. So, under the law, that is not stipulated that it should be patented, because it will not be a type of new invention. It is many people invented before also, and people are using it without paying the royalty. The reason is the invention is not patentable because it is stipulated under the law, not patentable. The ingredients are not fulfilled over there to patent it. One. Two, that the claimed invention is not excluded from the protection as stipulated under the law. And if it is there, excluded from the protection means that it will not be protected over there. At that instance, is stipulated under the law, then we can invalidate it. See, if a person has composed a music, for instance, a new music, and if it is patented, nobody could use such a music or such a rhythm. Suppose if he did not patent it, because certain musics are there, we are not supposed to patent it because it is in the public domain. At that instance, we can invalidate the patent because it is excluded from the protection. Is it clear?
Yes.
For instance, there is a law. Every motorbike man should have the license to drive. But what about the cyclist? Is it excluded from taking the license? A cyclist should have to take the license. What about
Yes.
A?
Yeah.
A cyclist should have to take the license from the government to ride the bicycle.
No, no, no.
Because that is excluded by taking the license. What about the bullock cart?
Motor.
Bullock cart.
Pardon?
Bull drawn cart. Bulls or cow or ox will draw the cart. CART cart. Drawn by the animal. Draft animal. Do you need the
That?
license from the government?
No, no.
Answer, they don't excluded from taking the license. So that the description and the claims comply with the requirements prescribed in the law and the rules pertaining thereto. If the description and the claims comply with the requirement of the prescribed under the law, the rules pertaining thereto, then only it can be patentable. If not, we can invalidate the patent because it is not fulfilled the criteria for the patent to be patented. So fourth one is that the person to whom the patent was granted but had no right to patent. Suppose the person to whom the patent was granted and had no right to the patent, a wrong person gave the right, we can invalidate it. And if the time body is there more than 20 years, yes, it cannot be protected. So fifth point is that the patent has not been assigned to the person who has the right to the patent. So a person who invented it, it should be assigned to him, not to a third person. If a third person has enjoyed it, at that instance, it will be invalidated. Suppose a son has killed a person, can the father would be held liable to keep in the prison?
Pardon?
The son has committed a rape or committed a crime or killed another person. Can the policeman will keep the father in the jail?
No.
Why?
He's not the one who committed the offense.
In the same way, if it is not patented to a particular person, then one can say invalidate that thing. Because it is not he who has invented. Somebody has invented, but he wants to claim it. Who invented it, and he will be protected, and who committed a crime, and he will be punished. Am I right?
Yes.
That the patent had not been assigned to the person who has the right to the patent, but that is given to the second person, other person. Suppose if you invented a particular patent, can that patent will be assigned to your wife?
If we follow the procedures, but without following a procedure, it will not be patented to him.
If the wife also one of the member in the invention, instead of husband taking the pride, he wants to make the wife happy, and he will patent it in the name of the wife. Is it clear?
Yes.
If the wife name it is patented, can the husband will file a case in case of the infringement?
No.
Answer is no.
Yes.
To whom it is assigned, and he should have to file it. And here it is not assigned to him, the person who has the right to patent, and somebody is assigned, so we can invalidate. So if the request for the invalidation apply only to some of the claims or some part of the claim, therefore the court shall invalidate such claims or part of claims. The court may require the owner of the patent to submit it for the purpose of examination. It is the owner, inventor should have to make it out and come forward. And publications or any other document showing their prior art which has been referred to either in the connection with an application for the patent or other title of the production of the field for the same or essentially the same inventions by the owner or by the patent with any other national or regional industrial property office like ARIPO, yes, you can make it so. Even the registrar of local, yes, you can. And in connection with any proceedings relating to the patent or the title of the production against upon such an application. So either you can, any person violate it, the patent or the title of the production granted to upon him, and at that instance, yes, you can bring an action against him and who violated it. The notice of the request for the invalidation of the patent shall be served to the licensee and the patent, if it is appears to be the court, the right to the patent belong to the person who is not a party to the proceeding. Notice of the request for the invalidation of the patent shall be served on that person who shall be entitled to join the proceedings. So notices should be given caveat. Before you are making a party to it, you have to give the notice. Before he is indulging him in this activity, you have to give the notice. And at that time, either he deny the notice or he contest based on the notice. So notice is very important factor. Like if you want to conduct your test, shall I give the notice or not? Timothy,
Yes.
suppose if it is a lightning test, then
Yes.
suppose if it is a lightning test, a lightning test cannot be given the notice. At any time, I can conduct
Yes.
the test.
Yes.
At the time, the notice is not necessary. But we have to be alert to the students, at least, because some of them may be sick, or some of them travel, or some of them suffering from diarrhea. Najwa diarrhea.
Yes.
Nini simas Kiswahili. Kutahiri.
What?
What do you say diarrhea in Kiswahili?
The
Yes?
I didn't understand.
Diarrhea, motions like a water. Naenda chuoni.
Okay.
What do you say in Kiswahili? Sikiliza mimi darasa, asante sana na shukuru sana. Mungu akubariki na kukulinda.